Family Homes Repeal Bill be considered by the Justice and Electoral Committee. Those of that opinion will say aye. Aye. Contrary no. The ayes have it. Call on members. Order of the day number 3.
Illegal Contracts, Unlawful Limitation on Regulators' Powers Amendment Bill, first reading.
Honourable Leanne Dalziel.
Mr Speaker, I move that the Illegal Contracts, Unlawful Limitation on Regulators' Powers Amendment Bill be read a first time. Mr Speaker, it is my intention to move that the bill be referred to the Commerce Committee for consideration, provided I have the support of the very generous members on the other side of the House who have recently been speaking on another bill. And the reason that I'm hoping that there will be support in this House for this bill is probably because the pressure for this legislation has diminished as a result of the settlement between the ANZ and ING, who were the original reason for this particular measure, and the Commerce Commission. And the Commerce Commission and ANZ and ING came to a settlement back in June 2010, which was after I had drafted this particular bill, so I wasn't as fortunate as the previous speaker on his bill, having had it drawn from the ballot at the first instance. I reinstated it into the ballot after the general election, and it was then that I was fortunate enough to have it drawn. However, the particular issue that came to the fore in that particular case, as I say, has been addressed with the settlement, but it doesn't prevent the same thing from happening again, which is why I think the bill is important, and which is why I hope that members opposite will agree to refer it to a select committee. I know that some members were mistakenly of the view that this matter is now addressed in the Securities Commission legislation and now the Financial Markets Authority legislation, but this particular situation arose out of having to preclude the coverage or the response of the two particular regulators, which were the Banking and Savings Ombudsman and the Commerce Commission. And the legislation surrounding them does not provide the same protections that are available under the securities legislation. So I just don't want to make that point, because I would be very disappointed if people didn't support the bill based on a misapprehension of the particular issue. Mr Speaker, there are a lot of people in this House now who probably don't have the same history around this legislation. Certainly it got a lot of publicity at the time, and some of you will have, or some of the House will not have heard about the ING ANZ Frozen Funds Group who were established, and one of their leaders, a guy called Gerard Princeam. And I actually brought a photo down to the House. This is a photo that sits on my desk, and it has Dalziel's Bridge written on it. And it's actually a photograph. I have no idea where Dalziel's Bridge is. If anyone does know where it is, it would be very nice to go and see it. But it could be Scotland, in case in there it would be called Dalziel's Bridge. But anyway, the reason that I always thought that this photograph was kind of amusing was because, well, it was because my press secretary always used to say "build a bridge," which was her way of saying "get over it," you know. So, but the message that came with this, and this was presented to me by Gerard Princeam, was because the strongest bridges are built while the rivers run dry. And the point is that there are times when we have an opportunity in this House to take up a case on behalf of a group of people who have been unfairly treated, or who have found themselves in a situation where they look to Parliament for a solution because they cannot find that solution within the community or within themselves. Mr Speaker, what this bill does is that it is a bridge. It is designed to be a bridge. It bridges the gap between those that have the power to impose intolerable conditions on others when a settlement is being negotiated, and to say it's a fair deal, and those who have no alternative but to accept the offer while it's on the table. And why do they have to accept the offer? Because those offers are always made with a deadline, and if the offer's not accepted by the time the deadline comes, then where do you stand? And does that really leave people in a position where they are on a fair bargaining basis? Now, that doesn't actually stop a hard bargain being driven, certainly even by a person in a dominant position. What this bill is designed to do is to stop them being let off the hook for behaviour that doesn't meet the legal standard imposed by a regulator, in this particular case, the Banking and Savings Ombudsman or the Commerce Commission. And I think the most difficult experience that I had as a Minister of Commerce was the sense of helplessness that I felt as I watched the inevitable domino effect that flowed from the original finance company failures in 2006. And the fact that my predecessor had already begun a consultation process in terms of the regulation of financial advisors, and I'd already released 9 discussion documents, collectively known as the Review of Financial Products and Providers, before the first string of finance company collapses occurred, really paled into insignificance against the extent of the losses that people had suffered. And it wasn't like the proverbial run on the bank either. Fixed-term investments meant that thousands of people literally held their breath until they could take their money out. And of course, once they could take their money out, there was the string of second failures, beginning with the collapse of Bridgecorp in 2007. And I received report after report after report of people facing individual financial ruin as a result of an investment decision in one of these companies. And it became very apparent to me that it wasn't greed that drove the investment decisions. I think greed had a place, but it was at the other end of the spectrum, but rather a lack of knowledge about the nature of the risk that people face. And I just want to quote from the media release that the Commerce Commission put out at the point of settlement. It is important that consumers are able to make properly informed decisions based on clear and accurate information. Investors decide whether to invest their money based largely on their appetite for risk. Throughout our investigations, investors have told us they would not have invested in these funds if the actual risk had been represented accurately. And that, Mr. Speaker, was what was so fundamentally wrong. The examples of the lack of integrity in the sector have been really the most appalling aspect of what has occurred. And although commentators rail against the failure to regulate fast enough, I have to ask the question, where were the major exposés that led people to be aware of the nature of the risk that they were facing? And the truth is that a lot of people in the media were silenced by threats of legal action from those who didn't want to have the real risk exposed. So we're dealing with powerful organisations, well-resourced, up against the little guy, and in the case of the media, even able to prevent them from publicising the risk that people face. Now, Mr. Speaker, I just wanted to say that because I did want a context for the legislation, and I just want to say what was objectionable about the ANZ-ING offer, and it said this: by accepting this offer, you agree to surrender, settle and release all other rights or claims that you may have against certain parties in connection with the relevant fund, including any claims or the extent of any claims of which you are not currently aware, and any claims brought on your behalf or for your benefit by another person. It also means you are agreeing not to benefit from any claim made by any other person in connection with the funds. Mr. Speaker, a release disclosure document was annexed to the offer letter, and this contained a list of those that were covered by the release. ING, ANZ, New Zealand Guardian Trust, and every single one of the financial advisors who had advised on the investment in the fund, and referred specifically to investigations being undertaken by the Banking Ombudsman and the Commerce Commission. Mr Speaker, the question that this really raised for me was whether, as a matter of public policy, companies that may have transgressed the regulatory framework that is designed to protect investors, whether they should be allowed to make a settlement conditional on these terms. So this is the question that this bill seeks to answer. It may not be the perfect answer, and there may be elements of it that the Select Committee would like to address. I'm perfectly open to that. What I do want this House to do, though, is to refer it to the Select Committee so that these people who didn't have their day in court can essentially have their day in court in front of the Select Committee.
The question is that the motion be agreed to. Jonathan.